Hello, my name is Abby Mitchell. Welcome to your online presentation on a guide to Nursing Midwifery Council disciplinary and fitness to practice procedures. This presentation should be reviewed prior to your attendance at the Simulated Learning Practice Day on a fitness to practice hearing, where you will be asked to participate in not only the event but with the decision making. This presentation aims to give you an understanding of the NMC disciplinary procedures and the fitness to practice process. It also enables you to respond appropriately when requested by the NMC as a result of a fitness to practice investigation, should that ever be required. The NMC will investigate accusations of misconduct, which refers to behaviour that falls short of what can be reasonably expected of a nurse. Lack of competence, knowledge, skill or judgment that means a practitioner is not fit to practice. Character, usually related in some form of criminal behaviour such as thefts, assaults, misuse of drugs, and at the worst end of the spectrum, actions such as manslaughter or murder. Not having the necessary knowledge of English, which includes poor handover of essential information about patient treatment, or drug errors caused by a failure to read and understand prescriptions, and serious ill health issues which have been unacknowledged and untreated that could seriously risk the public's trust in the profession. It is important to remember not the illness that the NMC are concerned about, it is whether the health condition has gone unacknowledged and untreated, and therefore this could affect the patients. This has been seen in past cases of harming patients done by nurses registrants with mental health issues that have not been acknowledged or effectively managed. You are highly encouraged to review the Fitness to Practice section on the NMC website, where you will find useful information on the topic. And you will also review current, ongoing and past cases that have come forward for fitness to practice hearings with the NMC and the sanctions and penalties that have been imposed. If you read what the NMC have to say about fitness to practice, they state that it is about managing the risks that the nurse or midwife poses to patients or members of the public in the future. It isn't about punishing people for past events, rather than looking at the risk now and in future. If professionals see us as punitive, those professionals are more likely to hide things that are going wrong or act defensively. This will make it difficult to achieve the kind of open and learning culture that's most likely to keep patients safe and members of the public safe. We want nurses to be able to identify and divulge where things have gone wrong and what has led to an issue or mistake occurring in order that we can put in place measures to prevent it occurring again. If people don't feel safe to speak out, we will not be able to look at these areas and mistakes will continue to be made. If the NMC is seen by people affected by unsafe care as there being no discipline to nurses, midwife and nursing associates involved, those people may be distressed if we don't take action against registrants who are no longer at risk. The NMC is very concerned that the public do not lose faith and trust in the profession. Changes to the Nursing Midwifery Council's legislation. Changes to the Nursing Midwifery Council's legislation has meant that the NMC now has new powers to resolve cases more quickly and proportionately, meaning that only the most serious cases progress to full fitness to practice hearing. The NMC is hoping to speed up this process to get cases resolved more quickly, and that also increases the safety to the public. The process can take some time and it is emotionally and socially very draining on the registrant who has been accused. There may be an inability to earn one's living properly and receive a salary. This can be a very stressful situation if a case is brought against you. Where a serious concern is identified, the Nursing Midwifery Council will be able to issue a warning to a nurse or midwife if they can show insight that they have recognised and taken steps to manage, improve, and there is no further risk to patients. They will also be able to agree measures such as additional training if there have been areas of practice which cause clinical risk to patients known as undertakings. And in cases where there is a minor breach of the code, they will be able to offer private advice to the registrant to help them keep their practice safe. So what is the process? In brief, the NMC receives an allegation from a patient, an employer, another regulatory body, or a member of the public. The case is assessed and the nurse or midwife is informed and asked to respond. They will then investigate, and having carried out a full investigation, pass their findings to 2 case examiners, who one of them is a registered nurse or midwife. The case examiners will now pursue whether to close the case, take actions, or refer to fitness to practice. If the case is to be decided to be referred to fitness to practice, then the legal team in fitness to practice reviews the case and advises, and then the case is passed to the fitness to practice committee, which then can be pursued via a meeting or a full fitness to practice hearing. Where there is no dispute between the registrant and the NMC and the allegations, then the panel can determine results and resolve them by agreement or a consent meeting. If there is a dispute on the facts with the registrant, then their case will be held at a full hearing, which is like a court case. Following the fitness to practice hearing, sanctions could be imposed, or the case could be found not proven. Here are a few good advice on responding to an NMC referral. If you are asked by the NMC to provide evidence or respond to an allegation, it is good advice to respond promptly. Remember, delaying your response could lead to accusations of failure to cooperate and even more charges. Make sure you deal with any referrer in a professional manner. This can help demonstrate you have insight into the problem or behaviour that has resulted in the complaint. If you are involved in an incident at work, it may always be advisable to make notes. Think about what's happened and why that might have happened. In future, you will always have those notes to refer back to should anything occur. If you are asked to respond to an allegation, remember to take help and advice from a union or a professional body or a regulatory solicitor with a background in healthcare fitness to practice. Don't try and manage by yourselves. Do get help and advice. Interim orders. In serious cases, whilst a fitness to practice case is ongoing, a panel of one of the NMC's practice committees is able to impose an interim conditions of practice order. The interim orders are issued when the case hasn't been decided, but it is severe enough that they want to ensure the patients are kept safe, and therefore it may be necessary that the registrant accused must practice under supervision or avoid certain areas of practice, or even be temporarily suspended. And this means that registration is suspended and the registrant is unable to practice on any part of the register on which they hold a registration. Remember that interim orders are not only stressful but also have financial considerations for the registrant. Investigations. The Investigations Committee usually begins by seeking documentary evidence of the factual issues and speaking to those involved. They ask for a response from the nurse, midwife or nursing associate, the registrant involved. It may involve health and language concerns such as a learning disability that's preventing a nurse to express herself clearly in a documentation or be able to calculate clearly and making drug errors. Therefore, in those cases, sometimes further reports may be requested following further examinations to ascertain if there is an underlying condition which the nurse can be helped with that is causing her problems in practice. Where harm or death to a patient has been caused, the investigation should focus on whether the nurse or midwife is likely to put a patient at risk of harm in the future. They will want to know, was there a deliberate decision to take a risk or make a clinical error? Was it just an inability to acknowledge lack of skill and training and professional competence? They would also want to know other organisations investigating. If a criminal investigation is taking part at the same time, this would take precedent over the NMC investigations. Are other health regulatory bodies like social work, health and services investigating as well? After the investigation has been completed, the case examiners will then decide whether or not a nurse or midwife has a case to answer and what should happen to the case. For example, they may decide no case to answer, but on reflection that a warning or advice would help the nurse in future to avoid possible further allegations. The case examiners should consider whether there's a realistic possibility that the Fitness to Practice Committee would decide, using the evidence gathered, that the incidences in the case in fact did happen, or that the issues that were presented at the time that caused the allegation to be made are still present. They need to decide whether the nurse or the midwife's fitness to practice is completely impaired. Remember, they don't decide whether the case is proven, they just need to decide if there is sufficient evidence and the Fitness to Practice Committee would be able to come to a decision. They may also decide at this time that they need further investigations to take place. If there is no case to answer at this stage, the case examiners can close the case. They may give advice or a warning or simply close the case and not take it any further. However, if there is a case to answer, they can recommend undertakings to be agreed with the nurse or midwife. If the nurse or midwife or nursing associate has accepted the allegations and admitted and recognised the failings, they may be able to recommend certain restrictions or rehabilitation is necessary for the registrant to undertake. Or they will refer the case to the Fitness to Practice Committee. So at this stage, this would be the conclusion. Or there could be a continuation to the procedures. Fitness to Practice hearings and adjudication. In the process, preliminary hearings may be held in private, and these could be used to resolve issues before a full hearing. Where there is no disagreement between the registrant and the NMC, it is possible that cases will be decided in a Fitness to Practice meeting rather than a hearing. If there is a disagreement between the NMC and the registrant about the important issue in the case, then a case would go to a hearing. Full hearings are held in public unless there is very good reason, such as the nurse's health, which means it must be heard in private. A full hearing is like a trial with witnesses and statements and documents and experts coming forward. It is very important that the practitioner in these cases has legal advice and help and representation. The NMC panel is made up of 3 people. There is a chair, at least one nurse or a midwife, and one lay person. The NMC has a case presenter who will present the case and a legal advisor or assessor who assists the panel in the points of law and procedure. Following the result of a hearing, practitioners can appeal against the decision or any sanctions imposed, and likewise the NMC, the professional body, can appeal if they think the Fitness to Practice panel's decision was too lenient. Possible sanctions. The possible sanctions at the end of the Fitness to Practice hearing will be taking no further action, a caution or order between 1 or 5 years given to the registrant which will appear against their name, a conditions of practice order for up to 3 years, a suspension order of up to 12 months, and in severe cases the registrar will be struck off, and it will be 5 years before they can be considered to go back on the register. And of course they will have to provide a great deal of evidence of what they have done in the meantime to rectify. I would advise that you review these sanctions on the NMC website and have a look at some previous cases and the type of sanctions that have been passed against registrants. I hope following your simulated learning experience you will feel more confident in the process, what occurs, and more knowledgeable. And we look forward to welcoming you on the day to your Fitness to Practice Simulation Learning Day. Thank you.